Hello, and welcome to the first webinar in our Health and Safety webinar series. In this first webinar, we will consider the very recent decision of the English Court of Appeal in the case of Serious Fraud Office against Eurasian Natural Resources Corporation Limited, which I'll refer to as ENRC. This case looked at issues of legal privilege and is of relevance to any criminal or regulatory investigation, including, for example, investigations being conducted by inspectors of the Health and Safety Executive. For those who may be interested, the second webinar in the series will explore the issues that arise when a regulatory inspector comes knocking on the door. And the webinar series will then conclude with the third webinar, which aims to provide a legal update in relation to health and safety cases. By way of brief introduction, my name is Kevin Clancy, and I'm a Senior Associate within the Commercial Disputes and Regulation team. I've been with Sheffer & Wedderburn since 2006 and obtained civil rights of audience as a solicitor advocate in 2013. I have experience advising public and private sector clients, have appeared in both the civil and criminal courts, and have engaged with prosecutors around criminal charges in a range of disputes, such as breaches of health and safety legislation, environmental issues, and other regulatory offences. I also had the benefit of a period of secondment at Crown Office within the Health and Safety Division, and so have experience of prosecutions from the other side of the fence, so to speak. Simply to aid the sound quality for the webinar, please be aware you've all been placed on mute. It simply helps in minimising background noise, or if you've come off mute, it would be helpful if you could remute it. The webinar should last around 25 to 30 minutes. In terms of the aim for this webinar, I hope you will come away with a better understanding of the recent Court of Appeal decision. More importantly, there are useful learning points arising from that case that should assist companies and their advisors if ever conducting internal investigations in response to an alleged criminal or regulatory offence. It is always better to proactively plan for the investigation you hope will never come, rather than reactively try and keep pace with a fast-moving investigation sprung upon you. A helpful starting point is a quick refresher as to what legal privilege is and why it is relevant to business. It is a fundamental pillar of the lawyer and client relationship that a client can be open and frank with his or her legal advisor, safe in the knowledge what is said between lawyer and client is kept confidential. The availability of legal privilege is a particularly critical issue for companies. If a document is privileged, either because it is in the form of legal advice or because litigation is anticipated or has been commenced, then it is generally protected against disclosure in legal proceedings and also from disclosure to enforcement authorities, such as the Health and Safety Executive in an investigation. As such, it has been seen as a key protection for business when seeking legal advice on the issues that they face. The slide sets out the two types of privilege in summary form. Legal advice privilege is defined as protecting communications between a client and his or her legal advisor for the purpose of giving or receiving legal advice. But that does not extend to communications with third parties. And the definition of, inverted commas, client is also rather tightly constrained. What that means is only those in the company that are authorised to seek and obtain legal advice from the legal advisor will have the benefit of legal advice privilege. In a large organisation, such a restriction can become problematic. As can be seen from the slide, litigation privilege is wider than legal advice privilege and is what the ENRC case was principally decided upon. It protects communications passing between a client and his or her legal advisor or a third party, and there is a well-established test. As the slide sets out, that means adversarial litigation is reasonably contemplated by the business, and the dominant purpose of the communication or document is the conduct of those legal proceedings. So, turning to the dispute that made significant headlines. In 2011, following a whistleblower report, ENRC began an internal investigation into alleged corruption and fraud. The whistleblower had made allegations concerning bribery and financial wrongdoing. It wasn't long before news of alleged corruption also hit the press. ENRC wished to carry out an internal fact-finding investigation. Lawyers and forensic accountants were instructed. In August 2011, the SFO became directly involved. It contacted ENRC and drew its attention to the SFO's self-reporting guidelines. The court judgment narrates a long and protracted period of dialogue between ENRC and the SFO. That narrative includes reference to a series of meetings in which ENRC would update the SFO on the progress of its internal investigation. There had also been suggestions that ENRC might disclose such documents to the SFO in due course as part of the self-reporting regime, but no agreement was ever reached. And the SFO opened a criminal investigation in April 2013. Upon doing so, the SFO wanted to get hold of various documents held by ENRC and which were created by ENRC's lawyers and accountants during the internal fact-finding investigation that I've already mentioned. For reasons that probably seem quite understandable, ENRC was rather reluctant to hand those documents over. In order to resist the disclosure request, ENRC claimed privilege in relation to the documents. That then forced the SFO's hand. The SFO was required to go to the High Court and seek a declaration that the documents were not privileged. As I'll come on to discuss, the High Court agreed with the SFO and set the path for this litigation to be determined by the Court of Appeal. The chronology of events does highlight a number of significant moments throughout the internal investigation, one or more of which anyone who has had to deal with the SFO, or any other investigator for that matter, may have had the misfortune of having to live through. At an early stage, the General Counsel for ENRC believed, as a consequence of industry chatter, that the company was now on the SFO's radar. Dawn raid procedures had been upgraded in anticipation of a dawn raid that may yet come. There had been an absence of assurances offered by the SFO, which was really of no comfort to ENRC. Difficult decision-making had to be taken around whether or not to make voluntary disclosures and the potential loss of privilege. There was a recognition that there could well be possible criminal and civil proceedings. Attempts were made to reassure the SFO that the company wished to be seen as being cooperative throughout the process. A long, drawn-out investigation exercise included numerous meetings, updates and reports, and there was also the challenge for the company to continue to manage the SFO's expectations of progress. So, what was in dispute? The documents that the SFO wanted to see are summarised in the slide and fell into four categories. Documents that can be categorised as interview notes. These were notes taken by lawyers of the evidence given to them by ENRC's employees, former employees, subsidiaries, suppliers and other third parties. There were documents that can be categorised as reports by accountants. These were materials generated by forensic accountants as part of a books and records review, with a focus on identifying controls, weaknesses and potential improvements within the company. There were factual updates which concerned evidence presented by lawyers to a committee within ENRC and also to ENRC's board. And there were emails between a senior executive and the head of mergers and acquisitions at ENRC, who was a Swiss qualified lawyer, and which I've described in the slide as correspondence with legally qualified individuals. In order to understand the issues in dispute, it's worthwhile briefly considering the High Court judgment that was in favour of the SFO, and a number of soundbites are set out on the slide. Dealing with both limbs of privilege, legal advice privilege was held not to apply. The interview notes were considered by the court to be in relation to individuals more akin to witnesses. Remember, former employees and suppliers were amongst those who had been interviewed. Put another way, the court felt that the notes were not communications between ENRC's legal advisors and the client. nor would it be said that the notes constituted the legal advisor's working papers. Litigation privilege was held not to apply either by the court. The disputed documents were said to have been created at too early a stage. It was concluded by the court that until the prosecutor was satisfied that he or she had a case worth prosecuting, no prosecution could exist, and so legal proceedings could not have been in contemplation. Even if a prosecution had been reasonably contemplated, the court held that none of the documents had been created with the dominant purpose of being used in any such criminal proceedings. Remember, ENRC began with a fact-finding investigation, and so the court concluded the documents had instead been produced as part of ENRC's engagement and dialogue with the SFO in an attempt to avoid such a prosecution. These conclusions were somewhat unhelpful. For litigation privilege, it had the chilling effect of shifting the relevant point for reasonable contemplation to very late in the process, effectively saying that the prosecution needed to be imminent. That was also very much at odds with how privilege may be deployed in civil proceedings, where it is accepted that litigation can be contemplated at the early stages of a dispute, and so such a distinction was not satisfactory, and the decision was not well received. To pose a question, if a responsible corporate body, keen to understand the facts that may have allowed an alleged offence to have been committed, is going to be forced to hand over such materials to an investigator, what incentive might really exist for carrying out an internal investigation in the first place? The Court of Appeal has now overturned that decision, which is positive news for those facing criminal or regulatory investigation. The court recognised a clear public interest in encouraging companies to investigate allegations from whistleblowers before approaching the authorities. Otherwise, companies might be tempted not to investigate such allegations at all. It is important to stress at this point that the question of whether documents are privileged does remain a question of fact, and so each case will have to turn on its own particular facts. However, it certainly appears to be the case that companies should now be in a stronger position to argue that documents they generate during the course of an internal investigation are privileged and therefore protected from disclosure. The Court of Appeal considered that the focus of the appeal concerned arguments over litigation privilege, and so did not actually resolve any questions around legal advice privilege. The Court was asked to address two issues in order to determine whether the documents were covered by litigation privilege, and these issues followed the well-known test. Firstly, whether criminal proceedings were reasonably in contemplation at the time the documents had been created, and secondly, whether the dominant purpose for creating the documents had been to resist contemplated criminal proceedings. On the first question, the court held that criminal proceedings had been reasonably in contemplation by ENRC on the basis that the whole subtext of the relationship between ENRC and the SFO was the possibility, if not the likelihood, of prosecution. ENRC was sufficiently concerned about the situation when it first commenced investigation in early 2011, and certainly contemplated the possibility of prosecution when the SFO first got in touch in August 2011. Also worthy of note, however, is the Court's observation that not every manifestation of concern expressed by the SFO, or any regulator for that matter, should lead to a conclusion that there is an intention to prosecute. So that means one should not necessarily assume litigation is in play in any dispute. That said, the Court of Appeal judgment was clear that when the SFO, and the same could be said of other regulators such as the Health and Safety Executive, SEPA, HMRC, and so on, specifically makes it clear to a company that criminal prosecution is possible and legal advisors are engaged, there is a clear ground for contending that criminal prosecution is in reasonable contemplation. For corporates wishing some room for manoeuvre, it is important to be aware that the Court of Appeal was sympathetic that large businesses do require to conduct investigations within the company in order to better ingather and understand the relevant knowledge held across the business. Put another way, to understand what on earth is going on. Such initial uncertainty will not prevent proceedings from being in reasonable contemplation. It is not necessary for a company to have discovered the full details of the alleged misconduct, nor is it necessary to be told that prosecution is inevitable. In the High Court, it was concluded that ENRC's dominant purpose was to investigate the facts to see what had happened and deal with compliance and governance issues. The Court of Appeal disagreed. In making the following findings, the Court's conclusions have a more pragmatic flavour about them. Firstly, the fact that solicitors prepare a document with the ultimate intention of showing it to the other side does not automatically deprive the preparatory legal work of litigation privilege. Secondly, legal advice given to head off, avoid, or even settle reasonably contemplated legal proceedings remains protected by litigation privilege, as much as advice on defending or contesting such proceedings would be. And thirdly, whilst reputable corporations will certainly want to ensure high ethical standards for their own sake, where a company is facing a clear threat of criminal investigation and prosecution, the dominant purpose why the corporation is investigating whistleblowing allegations is to prevent or deal with litigation. These findings are relevant to any regulatory investigation and pragmatically set the bar for litigation privilege lower than the High Court may have had in mind. Reference was also made in the Court of Appeal's judgment to another recent case, that of Bila against Royal Bank of Scotland. Royal Bank of Scotland had received a letter from Her Majesty's Revenue and Customs, HMRC, alleging that RBS had participated in various transactions connected with fraud and that HMRC had grounds to deny the bank's claim for VAT input tax. RBS conducted a large internal investigation. Bila and various associated companies were interested in seeing the documents produced in the course of that investigation, in particular the transcripts of various interviews conducted by RBS's legal representatives. RBS maintained that the documents were covered by litigation privilege, whilst Bila and the other claimants argued that RBS did not meet the sole or dominant purpose test, on the basis that RBS's investigation was more of a fact-finding mission. The Court agreed with RBS and privilege did apply, since the dominant purpose for the documents was use in litigation. Perhaps of greater interest, the Court held that HMRC's letter, communicating to RBS that there might be grounds to deny the claim for nearly £90 million worth of tax, was a watershed moment, as it strongly hinted that litigation was on the horizon. There was also the decision by RBS to instruct a specialist tax litigation team at the outset to lead the investigation, and which strongly suggested that RBS anticipated a claim and was gearing up to defend it. It was also worthy of note that the bank's collaborative and cooperative approach towards HMRC after receipt of this letter, the watershed moment, did not change the fact that RBS was preparing for litigation. And in relation to the ENRC dispute, the table there just illustrates the differing decisions between the High Court and the Court of Appeal on privilege. Whilst the Court of Appeal did not set out any guidelines or principles to assist in dealing with difficult questions of privilege in any particular case, it's possible to identify a number of helpful observations. As I mentioned earlier, each case will, of course, depend and turn on its own facts, but companies should feel in a stronger position to successfully claim privilege over documents created during the course of their own internal investigation. And companies ought to have the comfort that any subsequent decision regarding disclosure should be one for them, rather than one taken by the regulator. What must not be forgotten, however, is that the decision makers in a company and their advisors should not close their eyes to the possibility that a self-report to the relevant authorities should still be made. In other words, one shouldn't lose sight of the fact that there will be self-reporting options available. What then can be done to assert privilege over documents generated during any internal investigation and to avoid any successful challenge by regulators such as the Health and Safety Executive? At the outset of any internal investigation, identify and establish who the investigation team is going to be. That relates to both the internal team as well as the early instruction of external legal counsel. Who has the relevant knowledge and skills? How large should the team be, bearing in mind that the bigger the size of the team, the greater the chance of information leakage? Are criminal or civil proceedings reasonably contemplated based on the available evidence? If so, record that in engagement with your external lawyers. Record it in the internal documentation held by the investigation team. Set out what proceedings are being contemplated, by whom, and why the allegations and available evidence make such a conclusion a reasonable one. If not, but circumstances are to change as the investigation progresses, and which suggests that court proceedings might actually be in contemplation, again record it in writing and set out the reasons why the investigation team has come to that change in view. Maintain an audit trail that records documents and decision making throughout the life cycle of an internal investigation. Consider what communication protocols need to be put in place for the investigation team. How is information to be exchanged? What security protocols are in place? What technology or platforms are utilised for the exchange of information and documents? Distribution of the investigation documents should be carefully and tightly controlled and should almost always be retained within the investigation team. If documents are to be disseminated outside of the internal team, careful consideration should be given before doing so. And care should also be taken over the dangers of using the forward button in an email exchange, which then disseminates confidential and privileged documents further than was intended. You may remember at the outset I mentioned legal advice privilege. Where does it stand? It is worth being aware that the High Court judgment offered two key observations. Client will be narrowly defined. As I mentioned, only communications between lawyers and those individuals at the company authorised to seek and receive legal advice on behalf of the company will be protected by legal advice privilege. And legal advice privilege over a lawyer's working papers is only justified if the working papers betray the tenor of that legal advice. The Court of Appeal did not answer the question of whether the documents at issue were protected by legal advice privilege. It did not need to deal with the issue when reaching its judgment, and in fact considered that this would be a matter for the Supreme Court to determine at a later date. However, the Court of Appeal was critical as regards the law on legal advice privilege as it currently stands in the UK. Such a narrow definition of client is unhelpful, some might say unworkable, and entirely misses the reality of the situation when applied to medium and large-scale corporate entities. The law is, however, here to stay for now. It may be possible to glean some guidance and assistance from another very recent case, this time arising out of investigations undertaken by HMRC. The underlying facts are not critical. It need only be said that this case involved an attempt by HMRC to obtain documents in the hands of a solicitor firm concerning property transactions which would assist HMRC in establishing relevant information about the solicitor firm's client. This judgment was issued one day after the Court of Appeal's judgment in ENRC. It therefore does not have the benefit of the Court of Appeal's reasoning, but its conclusions are nevertheless very closely aligned. It was held that all documents seeking or giving legal advice are subject to legal advice privilege, and that also included, in redacted form, client care engagement letters, and thus the fact a person has even sought legal advice at all. More illuminating, perhaps, are the documents that failed to meet the test. Those included letters routed through a law firm that would not otherwise of themselves attract legal advice privilege, draft reports that were forwarded to the law firm. There was no hint of legal advice having been sought in relation to the relevant transactions. Emails and faxes that were exchanged between lawyer and client, but which did not contain or give any evidence of the giving or receiving of legal advice, and email correspondence between the client and other external legal advisors which the lawyer was simply copied into. The emails contained details of discussions of potential transactions, but that would not qualify for legal advice privilege on their own. Put shortly, the simple fact of copying documents to a solicitor could not clothe the documents with privilege that the documents otherwise lacked. In conclusion, the Court of Appeal judgment is, generally speaking, good news for large companies and their external advisors. However, there is no room for complacency. Assertions of privilege will, of course, be closely scrutinised by third parties, regulators or law enforcement agencies, and each case, of course, turns on its own facts. What must not be forgotten is that it is still a fundamental prerequisite for litigation privilege that a party can demonstrate to a regulator that the documents are being properly withheld because litigation was both reasonably contemplated at the time of any investigation and that litigation was the sole or dominant purpose in relation to the documents in question. It is not enough to simply make a claim for privilege and then hope for the best. Those conducting an investigation need to be clear as to what they are doing and why they are doing it. The purpose of any investigation should be documented in writing. There may, of course, be any number of reasons for the investigation, and that includes good governance and compliance. But if contemplated litigation is the dominant or overarching one, this should be made clear, and that then avoids any difficult or awkward conversations further down the line. And that slightly serious note brings this webinar to a conclusion. I hope you found the topic to be an interesting one and that it might have provoked one or two thoughts around the challenges arising from an internal investigation. Should you have any questions, please don't hesitate to get in touch. The second webinar in this series is scheduled for 13 November, and I would be delighted if you would join me. This webinar will deal with the subject of what to do when a regulatory inspector comes knocking on the door. And that just leaves me to finish with thanking you for attending this lunchtime webinar. Thank you.